I just feel like we're putting this novel legal media issue in resolving this and maybe wanting that heard over the fact that this case has been open since November 2022 and needs to be resolved.
We are on the record in the matter case D21 or D. Please confirm your appearances.
Good afternoon, Your Honor. Shannon Wilson, bar number 9933, on behalf of plaintiff, who is also present.
Good afternoon.
Thank you.
Mr. Burton.
Good afternoon. Good afternoon, Your Honor. Michael Burton, bar number 14351, and I'm here with who is present to my right, and we are both appearing via video.
Good afternoon and welcome. And this is the time set for a hearing on an over-shortening time on plaintiff's NRAP 8 motion for stay. We have an evidentiary hearing that is scheduled to begin on Thursday, May 2nd at 9 a.m. Any stipulations to it?
No, Your Honor.
Here's where I'm at, and I set this, as I indicated, on an over-shortening time. I'm not inclined to stay the media order request that has been filed into the case. There is reference, and this is the reason it was set on an order shortening time, to as to whether or not there's a stay, there's a basis to grant a stay as to the existing evidentiary hearing date pending the filing of a writ. In terms of appellate practice, if a notice of appeal is filed, then that in many respects divests the district court of jurisdiction to proceed as it relates to those issues that are subject of the appeal. That's obviously not what is contemplated in this situation, given the fact that there's been no final judgment. A writ that's filed does not operate at the same level in terms of divesting the court of jurisdiction, and that's the reason for the motion for the stay. I've reviewed the papers, and the one issue that I agree with in terms of what the defendant has offered on Mr. respect is the extent to which the court entertaining a stay would simply, because there has been no writ filed, would simply operate as a continuance of a trial that has already been continued previously. And again, the triggering event for a regular appeal is the filing of the notice of appeal that gives the court notice that there are proceedings pending in front of the appellate courts. To my knowledge, no writ has been filed. That's certainly not flagged in Odyssey, and so that becomes the issue for the court. Certainly, if there is a writ filed prior to the initiation of the evidentiary hearing, then there certainly is a basis for the court to stay the proceedings pending the result of that appeal, based on the issues that have been raised and given the recent decisions from the Supreme Court. That's really how I look at this. I would not be inclined to stay these proceedings if there is no writ that's been filed. But if there is a writ that is filed, then I would be inclined to stay the proceedings, because I think these are important matters that the Supreme Court needs to weigh in on in terms of defining whether or not there is a line of demarcation that I don't know exists based on the recent decision, and recognizing, as I indicated in my order, inherent in any child custody litigation where I am required to consider the best interest factors of NRS 125C.350 is our mental health issues, mental health of parents, emotional issues regarding the children. So I recognize that's inherent really in any best interest analysis, and I'm required to consider that. And those become issues of relevance and significance for the court. Certainly I recognize the significance of the request and receiving additional guidance to the extent there is any coming from the appellate courts. But I wouldn't be inclined to delay this matter any further unless there was a writ actually filed. So that's the essence of where I'm at. Anything you want to add, Counsel?
I appreciate that, and we've been working very hard to try to get that writ prepared, but as you might imagine, these things always take a little bit longer than we hope. So was trying to get it done by last Friday, and that didn't happen. We're trying to get it done before the hearing today, and we're still not quite there. So I do expect, and I think I would be overly optimistic to tell you I was going to get it done today, but I think we will for certain have it done tomorrow.
Okay.
So. but I completely appreciate the court. I would also say, though, that that is not one of the factors that goes into whether or not the court should grant a stay under NRAP 8, right? It is oftentimes the case that parties come to the court and they ask for the NRAP stay, and that is partly so that they have enough time to be able to do the writ petition. I am deeply sensitive both to, and I want to acknowledge this, Gamble's argument in his own opposition that this is stressful for everybody, and so we want to make sure that that is done. But I also want the court to recognize it is a heavy burden for us to be simultaneously continuing to prepare for a trial while also preparing a writ petition that is very important and is grappling with issues that were not defined by the Supreme Court. So there is a big balancing act here, and that is not actually one of the factors for the court, right? One of the factors for the court is that the factors are, is it likely to cause harm if the stay is not granted to the children? I think the court just signified here that that is true. The harm on the, as well as the children on the party, Mr. has provided you with his analysis of that. Whether the move-in is likely to prevail on the merits, yes, we have analyzed that and said that she is. I think this court has also just expressed that it has concerns whereby it thinks that she probably should prevail on the merits. We might disagree the whole breadth of that. And then finally, other equitable considerations of the court. And none of those considerations go to whether or not the petition has been filed before the hearing that it seeks to stay. Thank you.
All right, Mr. Burton, anything you wanted to add?
Yeah, I do. I agree with the court that there should be a writ filed to make this request, but I do have some concern with the court saying that if this writ is filed by the time the trial happens, that we're going to continue the trial, being that now we are under a day and a half away from this trial, and this decision of Your Honors was, weeks ago at this point, or at least long enough that this could have been done. So it does function as a stay or a continuance in a way. And we talk about, harm being caused, Your Honor. I just feel like we're putting this novel legal media issue in resolving this and maybe wanting that heard over the fact that this case has been open since November 2022 and needs to be resolved. And it's in another continuance, I think does cause harm to these children that outweighs resolving this media issue. So I want to make that argument. And then if the court is still inclined to grant a stay, essentially continuing the trial if a writ is filed, which it sounds like there is going to be one. In my experience, writs are resolved between 7 and 21 days. And I would like a mechanism for the court to check in on this writ and it's immediate, and when it's resolved, have some sort of immediate hearing and get this matter then back on calendar as soon as possible so that we're not pushing this past summer or something, because I just think pushing this to close to 2 years, I don't understand how the court could not see that that is really bad for this family as a whole.
Listen, here's where I'm at. And certainly, I find, based on the motion, that the bases have been met for the court to entertain a stay. I do agree that the filing of the writ is not a prerequisite for the court granting a stay. That being said, that's unique to this particular case. And Mr. Burton points out, and Ms. Wilson, you've been involved for quite some time. This matter has been pending for some time. And I believe I discussed that in the order, just given the length of time. Some of that was given the fact that there was a full-blown custody evaluation that created some significant time delays. This has been continued previously as a result of the media request issue. And we were ready to go at the last trial date. That's why it's particular to this case that I wouldn't be inclined to entertain the stay without the filing of the writ, simply because on this particular matter, this case has been pending for some time, and I agree that these parties need some finality and resolution. And they are, the value of a writ is that those generally are going to be heard in a more expedited fashion than obviously an appeal. So if there is some type of resolution quickly, the court will reach out to counsel, and I will have this calendared on my first available full day of trial. So once that communication is received, counsel will be notified, and the matter will be back on calendar. That's assuming, again, the writ is filed. As much as it is not a prerequisite, I do find it incumbent for the court to have that in this particular instance filed before I'm willing to state the case. But if the writ is filed, then the trial would be stated. Okay?
Okay. Thank you, Your Honor. And I have a question then for Ms. Wilson. Just because we both are prepping, we have trial coming, and I don't know the right way to ask this, but do you have an expectation? Are you for sure filing this, or when? So I know to plan appropriately with my clients based on what the court just said.
Yes, Mr. Burton, for certain the writ petition is being filed, and in light of what Judge Duckworth has said, we're going to absolutely make sure it's filed tomorrow.
Okay, so thank you for that.
And I will, Mr. Burton, I will also just keep you apprised as things are moving forward, so that you have an understanding of when exactly that's going to happen.
Okay, I'm going to rely on that then, and based on what the court just said, as relates to prepping my client then. Is that fair?
Yes, it's fair.
Okay. All right, thank you for your appearances.
Thank you, Judge.
Thank you.